Welcome back to Higher Exchanges, the #1 independent cannabis investing show, where we break down complex cannabis markets into clear insights you can actually use. Here are your hosts, Jesse Redman and Morgan Paxia.
What is up, guys? We're back for you live listeners. We are 5 minutes late. I apologize for that. I am Jesse Redman, Chief Strategy Investor Relations Officer at Leaf Brands, and I'm back with the smartest cannabis investor I know. He's tan, he's grizzled, he's a veteran. He's Morgan Paxia. Morgan, how are you, man?
I'm good. The tan definitely helps cover up the grizzledness, right? So yeah.
I know. I just keep getting more and more grizzled.
Yeah, no, I'm looking forward to the show today. I was just thinking as we were hearing the intro music, I was like, today's show feels like especially on point.
Yeah. Yeah, the ratings suggest if you talk about political things and rescheduling, people like to hear about that stuff. And sometimes I get sick of it, man, but today it sure is topical. And I think we have a perfect guest for it. Christian Bax, welcome to the show. Senior attorney at the Lockwood Law Firm. That sounds like the Ohio State University, but it's called the Lockwood Law Firm. Christian, welcome to the show. How are you, man?
I'm doing very well. Thanks for having me, guys.
Yeah, I was thrilled to see you for many reasons. One is that you showed up with a microphone. You look like you're a podcaster over there.
Thank you. I want to make sure you guys have good, you have good audio for your pod and for your audience.
It is so helpful. Sometimes some of the guests that I love the most, I bang my head against the wall as they stare at their MacBook with bad sound and bad video, and you're showing up on camera with a microphone. So first step, very good. And nice to meet you, Christian.
Thank you.
And so much to cover today. We have a packed agenda, as we usually do, a ton of content. But before we jump into it, Morgan Paxia, we talked on the phone earlier this week about AI and cannabis. We had a fun chat. Patrick on your team is doing some cool work over there. Before we get into it, do you care to tell me about how it is impacting dispensaries and how Flowhub might be able to help folks?
You got it. Well, AI is changing how cannabis retailers operate. Flowhub recently launched Flowhub MCP, a new AI connector that lets you run your dispensary by talking to AI. Instead of clicking through reports and navigating your POS, simply tell AI what you want to accomplish using plain language. Flowhub MCP gives you the freedom to connect the AI tools you already use, like ChatGPT, Claude, and Gemini, so you can analyze your business, update pricing, move inventory, and create promotions. Learn more at flowhub.com. And I can attest that that is very real. Our team already using it, and it's real cool.
Nice. Yeah, I'll have to look into that more. I don't have a dispensary, but always curious what Flowhub is up to. And just in general life, man, you and I were talking online about all the different things we're using AI for. And do you Claude here? Do you chat over there? Do you Gemini over here? And yeah, it feels like we're entering a new era where the more educated you can be, the more productive you can be. And yeah, shout out to Patrick Ray on your team. I'm excited to chat with him and see what he's doing over there. I think the ones that are the innovators and on the edge of this, I think there's going to be a good ROI. So yeah, if you're a dispensary, check out Flowhub, see how their AI can integrate and help you out there.
Yeah, I like the dual plug. It's a little bit of Flowhub and a little bit for Patrick with the AI first cannabis group that he's been doing. It's super interesting. I mean, I was just on a board call earlier with another group that's going to be joining in because everyone wants to know what others are doing, how they're using it, how we can learn from each other, because it's just total white space. It's really cool.
Yeah, it used the word plug, which I understand why you use the word plug, but like to me, it's just totally sincere. It's like, here's where we are in life. AI is here. If you got a dispensary, you want to use the software. With Patrick's thing, partially a plug, but just more like, how do we all work together in this industry to figure things out and get better? And I think that rolls well into talking about Christian. Christian, you seem like you're the perfect guest for the show. Super excited to talk about the hearings. I think that's the biggest thing that's been going on in the cannabis industry for the last few weeks here. So it's good to get some inside perspective. But before we jump into all those details, Christian, tell me a bit about who you are and what you do at the Lockwood Law Firm.
Sure. So I'm a Floridian. I'm a Floridian attorney. I got my start in the industry as a regulator in Florida back in 2015. Worked for the state for 3 years and was the director of the OCU, which then became the OMMU. Left, went into private practice. I've worked in industry for an MSO, and then for the last about year and a half, I've been with the Lockwood Law Firm. Lockwood Law Firm is a Florida regulatory and administrative firm. We are very, very active in the Florida medical marijuana industry. We represent several Florida MMTCs, which are the license type in Florida. They're all vertically integrated. They're very large licensees compared to other states. I do a lot of that work. That's kind of my bread and butter from where my career has gone. And I'm definitely doing a lot more than I thought I would be doing last year, of like federal work, of working on DEA registrations, helping clients kind of prepare or understand what's happening with the federal government right now. And that kind of led me to go up to the hearing that we're going to talk about today, just kind of covering it and trying to get as much information from that process as possible.
You're still digging there, Christian. I don't know if your notifications are off.
Yeah, let me, sorry.
Good. You're good. Take a second. No stress.
I tried to quit it's not my phone. It's my iMessages on my computer.
Are you on a Mac?
Yeah, I'm on a Mac.
If you go to that upper right-hand corner, maybe click that Do Not Disturb button. Don't worry, we'll edit this out. I'm just kidding. I've never edited the podcast before. We'll do it live. Give you a second there. Post. Yeah, we'll fix it in post. Don't worry, man.
Okay.
Well, while he's getting that sorted out, I mean, so Christian got connected to us via Emily because Emily, with the work she's doing at Sunburn, has been doing a lot of work with Christian. So this was a great opportunity to meet Christian and hear more about it. I've obviously heard a lot of great things from Emily and the work that they've done in Florida. So it's good to all be connected here today and digging in on this DEA situation.
Yeah. How did you get into the whole cannabis industry, Christian?
One second. I'm trying to still do the do not disturb thing. I'm sorry.
You're good. I think on the upper right-hand corner, if you look in the upper right-hand corner of your Mac, mine has like a moon you can click. That'll make it go into do not disturb.
I'm looking. It doesn't have that.
How about if you go to that box? How about next to the time in the upper right-hand corner? Do you see a slider box you can click on?
Yeah.
That is a drop down with do not disturb.
Yeah, I see it. Okay. Do not disturb. Cool. All right. Do not disturb is turned on. Okay, cool. So how I got into this industry. I actually did a project when I was in MBA. I went to a school that was very focused on entrepreneurship. And the first class that they make you take, or one of the first class they make you take there, is called New Venture Creation. And so you have to pitch a business idea and then get your classmates all kind of vote on who they think the best ideas are. And then the top 5 build the team from the people who weren't in that top 5. And then you kind of build out a business on paper. At the time, so my family does a lot of investing in like commercial agriculture, like Iowa corn farms. My mom's from Tuscaloosa. My dad's not a huge fan of any kind of drugs. And so I thought like, well, I may as well do something on paper that I would never do in real life. So my friends and I built a marijuana company on paper. And this was in 2013, right? So I was already a barred attorney at that time. And one of the things that my best friend and I actually encountered was this whole concept of competitive applications for marijuana licensure. So being a lawyer, he's kind of a business strategy and ops guy. We were kind of at the initial cresting of the competitive application process when people were really starting to think about it. That process was being professionalized. And then I probably made the worst financial decision of my life of, instead of just doing that full time, I became a regulator for the state of Florida and graded applications instead of writing them. So I looked to apply for a job. I sent my resume to the state of Florida because I'm from Tallahassee. I wanted to come home from Boston. And I told some of the guys that I was sharing my resume with, hey, like, show this around, and feel free to edit at your leisure, like remove the cannabis stuff from it, because this is this Governor Scott administration. It's a conservative Republican governor. And they were like, actually, don't do that. There might actually be kind of something that's up your alley where this is relevant. And I ended up being like employee number 2 at the Office of Compassionate Use and became the director.
Oh, cool.
That was my entree.
Very cool. Well, it sounds like you have a great background for this, Morgan. Let's jump into these hearings. But before we get into the nitty gritty, you want to help us set the stage here of what we're jumping into?
Yeah. So what was over the last 2 weeks? There was closed session hearings, right? There was no public access. So you had to be an attendee to actually hear what was going on. And this was, from my understanding, was supposed to be a narrow focus discussion for the DEA to, they had a list of witnesses and whatnot that were coming in to talk about rescheduling of cannabis, and again, supposed to be narrower beyond medical, and I honestly have not really kept up with much of the day to day, because once I knew we were going to have Christian on, I was like, I'll just get all caught up here today with what was actually going on. Where did the conversations evolve to? Did they get off topic? Like, what actually happened? So Christian, for those like me that have not followed every day or what was available every day, what were the hearings actually designed to accomplish? Why don't we start there?
So the hearing itself was a hearing on the notice of proposed rule from the DEA, which would reschedule the entire category of marijuana. So as I'm sure you guys and probably a lot of your listeners are aware, is that, several months ago, the Attorney General, by final order, rescheduled medical marijuana. Basically said, if you've already been federally approved, or if you're a licensee operating in a medical marijuana state and you are abiding by those state medical marijuana laws, you are now Schedule 3. This was the entire category, the entire universe of marijuana. Are we going to reschedule that? And obviously, anybody who follows this issue, there are people who are opposed to doing that. And they petitioned for a hearing. And the DEA made the interesting and kind of unusual decision to exclude proponents. So the industry was not represented in this hearing. People who are advocates for marijuana. And I'm going to stick with marijuana because of this particular thing. I understand the parlance between cannabis and marijuana, but the federal government, it's marijuana, and this hearing is marijuana. So it'll just be kind of easier to stick with that, especially kind of comparing my notes. So I don't mean to say the wrong term, but I'm being specific with my language. So what they were basically there to do is, under federal administrative law, it's incumbent upon the federal government to defend and support their proposed rule, which would reschedule marijuana, against some pretty fervent opposition from a pretty diverse group of petitioners.
Was it a cross section of industries that these opponents were coming from? Was this a specific area? Just kind of like who were like the major groups that were there advocating that cannabis should not, or marijuana should not be rescheduled? So
the first, probably the most obvious, is Smart Approaches to Marijuana, Sam, which is probably the most prolific anti-marijuana.
He's a huge fan of the pod, by the way.
Yeah. That's right. So Sam was there. Also there were 3 opposing states that had joined together. So Nebraska, Idaho, and Indiana. Sam and the opposing states actually have the same lawyer. So they both use tort and law. They both use Bill Barr's law firm. So when they would run around doing, at the beginning of the morning, every morning, when people are doing their introductions, the same gentleman would stand up and he and a couple other lawyers were representing both of those groups. Tennessee Bureau of Investigation was also there. They are not part of that group of 3 states. Now there were also there were 2 specific individuals One was a physician and one was a pharmacist. And they also put on witnesses. They made their case. The physician had an attorney. The pharmacist was pro se, so he represented himself, and he actually led a direct of his own witness as well. Then there was basically a drug testing company, an advocacy group for basically looking for harsher penalties on marijuana, harsher restrictions on marijuana in order to prevent intoxicated driving. So as you can see, like a very kind of wide array of perspectives on people who would oppose marijuana.
So if the position of the DEA is only inviting those that are opposed rescheduling, does that mean they have a position on it? Or I'm just trying to like get a sense of what were they trying to accomplish, and like what were like some questions that they were looking to discover in these hearings?
So DEA owns this issue now. I mean, DEA has taken the affirmative position that marijuana should be rescheduled. So they are what? No, yeah. So this hearing, they have proposed by rule to reschedule all of marijuana. They have put that out into the universe. So unopposed, if nobody said anything and there was no hearing, that would move forward and they would just reschedule marijuana. So DEA now owns this issue. The reason I talked to some of the DEA attorneys. I haven't specifically on the record gotten them to say this, but the legal reason why they didn't allow industry or advocates in to speak was because they're really not affected parties. Like they benefit if the rule goes through, and if the rule doesn't go through, well, it's like they were going to argue it for it to go through anyway. The people who are affected would be the people they're already in litigation with, or the people who are threatening to sue them over rescheduling marijuana. Now, the practical reason why they don't want those people in the room, they don't want industry or advocates, is because it's very important for the DEA, and we'll get into what they're specifically asserting in their case, but they don't want people testifying that marijuana has no harms. DEA take the position marijuana should be rescheduled, but marijuana affirmatively has harms. That's important because they want marijuana to stay scheduled. If they had people testifying that marijuana doesn't cause harms, has no propensity for abuse, or very, very low propensity for abuse, or basically should be scheduled similar to alcohol, it disrupts their case. It kind of muddies the record. And so in his opening statement, the lead attorney for DEA said, let me be clear, when we're talking about marijuana, one of the ways it's very important to think about this, Judge, is that every party you're going to hear from in this hearing concurs that marijuana has harms. So boom, you have now ensured marijuana should be scheduled. That's the first step. The next step is, okay, now marijuana must be removed from Schedule 1. And then Schedule 3, now we're just debating about which Schedule 2 through 5 marijuana should be in.
Huge implications.
Huge, yes.
With that. Yeah.
Yes, very big. So, I mean, their affirmative case basically comes down to like three things that they essentially need to probe. So first is that marijuana, based on a two-part test, which they basically created to reschedule marijuana, that it should not be Schedule 1, that there is a medical use for marijuana. The second would be that there is a moderate or low potential for abuse of marijuana. And then the third would be that there is some accepted safety, there's accepted safety for use under medical supervision for marijuana. So these are kind of the overarching three things that when you're making a debate flow, that they're trying to assert that then the opposition needs to attack, because those are the legal criteria for what they're trying to do with marijuana.
So one last for me, and I'll pass it to Jesse. But so I did see you shared some notes from after day one, and it seems like this was potentially consistent throughout. But if this is talking about full rescheduling, medical's already been rescheduled. Why was there so much talk about the medical aspect of it instead of just because to me that still seemed very, very much what's already been done instead of, and gave the potential opposition more to try to attack versus, moving to just full rescheduling. Does that make sense what I'm trying to get at?
Yeah, it does. I mean, I think it's because of the procedural posture of what DEA has chosen to do, and frankly, what FDA recommended that they do, which is, the way federal, just taking a quick step back, and then I'll get there, is that the way that this rescheduling process works is FDA via HHS makes a recommendation to DEA. And that's partially legally binding and partially like advisory. So it's legally binding in the sense that if FDA tells HHS and HHS tells DEA, this drug or compound should not be scheduled, DEA doesn't have the authority now to schedule it. But if they say it should be scheduled, DEA has a decision of like based on FDA's advice, where it should be scheduled or where it should be rescheduled. So because DEA is taking the position that this is a drug that should be scheduled, it's a drug. It's covered by the FDA. So the determinant of which schedule it falls under, 1, 2, 3, 4, or 5, is based on medical criteria, what this medical science says about what it does, what its potential for abuse would be. And this was a very strange argument. And frankly, I think all of the attorneys involved in this case, DEA and the opposition and the judge, kind of struggle with this because never in American history, never in this system that we've built with FDA and DEA, their collaboration for scheduling drugs, have we had a drug that we're basically saying an entire, organic plant matter should be scheduled as a drug rather than a specific identifiable compound. And because of this kind of and it already exists, it's already very widely consumed. There's already a lot of science to suspect that this is Schedule 1. It's one of, if not the most studied drug in America right now. When you go on PubMed, I think there's like 10,000 articles that you can pull up that are about marijuana. So it's very much a square peg in a round hole. Like the alcohol got the benefit of basically getting the treatment that it did and getting exempted, because like alcohol would have the exact same problems marijuana does. But the problem is now they're having to kind of justify, okay, based on our scheduling system, how do we make this work? And we're focusing on like the DEA was very intentional to the judge. You need to not think about all of the elements that go into recreational use, the potential harms, the political and social impacts. That's not material. What's material is you have to look at the compound itself, at the drug marijuana, the category, and you have to analyze it based on whether or not it has, an accepted medical use, that there's science that supports that medical use is, that is essentially effective for that use and that it's safe, and that this thing isn't so super addicted that it should be kept in Schedule 1 or it couldn't be in Schedule 1. It should be kept in Schedule 2.
Yeah, I think the problem for me with this whole thing is that there's the whole premise is fundamentally flawed. Like, even not talking about whether cannabis should be descheduled, which should be a distraction to today's conversation, is that you're taking a plant and you're trying to bifurcate it into two things, medical and adult use, which to me is a flawed premise in the first place. But then you say, okay, medically this plant is Schedule 3. Figure out what the goddamn same thing is for somebody who classifies themselves arbitrarily as adult use. And so I go buy an ounce of flower. I share half of it with my dad, who's a medical patient. I smoke half recreationally. What is that flower? And the flower doesn't know what it is, right? The flower just knows that it's helping you, but it doesn't know if it's Schedule 1, Schedule 3, or descheduled. And so like, I always feel like I have some obligation to just object to the premise. And I'm sitting here on ChatGPT seeing that Xanax is Schedule 4.
Yeah.
It's just like, Jesus Christ, guys, this makes no fucking sense. Like alcohol, which kills, I don't know how many hundreds of thousands of people. Cigarettes kill hundreds of thousands of people. Xanax, go take that for 3 months and try to get off of it and tell me how that one goes. Is that one not highly addictive? Does that one not have potential for abuse? Oh, that's Schedule, what did I say? 4.
Fentanyl is Schedule 2.
I know. So like the whole thing, I mean, this is a distraction of the conversation, but just hearing.
Well, I'll tell you who agrees with you. Jesse, I'll tell you who agrees with you. The judge in this case agrees with you in that sense that this distinction that we've drawn between medical and recreational, like it, at the end of almost every witness's testimony, when everybody was done asking questions, he would say, okay, I have a question for you, witness. And he would either show or read the federal definition of marijuana, which does not make a distinction between recreational and medical, and says, is this what you understand marijuana to be? And he's like, it made it very clear that is what he thinks about medical marijuana. I mean, marijuana in general. He does not draw a distinction between medical and recreational. He is considering the entire category itself.
Yeah. Which just makes total sense. And so I feel like some moral obligation to object to the fundamentally flawed premise of dividing one plant into these two categories. And I think the distinction between adult use and medical is also relatively arbitrary. And as Dennis Perone said back in the day, all cannabis users are medical patients, whether they know it or not. He said it much better than that, but I think that's a valid thing also to bring up. Like if you're using cannabis regularly, take a look at the mirror and figure out if it's medical or really recreational, because a lot of us, like me, who use cannabis on a regular basis, I'm probably using it for sleep or anxiety or whatever it is, but I just throw it in the category of, oh, you want to get stoned. It's like, no, I'm choosing a different alternative to, the outcome that I want. So enough of Jesse's philosophical ramblings. Let's get back to the show.
The DEA made the point that you just made. They, through their witness, Corey Birchman, so everybody was allowed 2 witnesses, and one of the DEA's 2 witnesses is a pain management physician out of New Hampshire. And that's on the record. They asked him about that distinction, and he's like, I don't draw a distinction between medical and recreational marijuana. Frequently, a lot of recreational, what we deem adult use, is really just people without a medical card or without doctor supervision treating a medical condition. That is something that the DEA got on the record.
Well, we
created the DEA literally agrees with you. It's official, which is one of the most shocking things is the positions that DEA took. It's like bizarro world. It's like if you got in a time machine, DEA of 2018 would not recognize the DEA's positions of 2026. It's striking.
Yeah. Last anecdote on that, my son, who is 16, goes to high school in Santa Barbara. And so people are smoking weed, ripping vape pens, the whole thing, welcome to California in 2026. And he has one friend who smokes, hits his vape card all the time. So I was like digging in a little bit. I'm like, well, tell me about the kid. Because in my mind, I'm like, this kid is probably just treating something medically he doesn't know. And he's like, yeah, he has ADHD and his dad won't let him take, any of those, Ritalin or other medications. So the kid who's 16 is looking for an answer to how he feels, and so he is hitting the vape cart, which people view as the kid's a stoner or he's looking to get high, when really the kid is probably just treating in the background this medical problem in a different way. And so anyway, I think these conversations, are important broadly about cannabis, but getting, back into this hearing specifically, just take us inside. I think that's what people are really here for, Christian, is we're sitting on the outside. I'm catching some of the media reports. I'm catching some Dale's report. I'm reading some Marijuana Moment. I'm over there on MJ Biz, whatever we got out there. I'm just trying to soak in what's happening. But, bottom line, you're the dude that was in the room. So take us inside there. Like what stood out for you? Like if you're talking to an audience of ours and they're like, hey man, this guy was in the room, what the hell happened? Like, give us the bottom line. And what stood out the most? What shocked you? What are the takeaways?
Well, I guess I'll start at the beginning. I was very surprised with the lack of industry presence there, honestly, and frankly, media presence too. So, like, I'm one of, I think, 3 people in the gallery that was like not an employee of the DEA that was there for all 2.5 weeks, and like so, the prep they. When you walk into this room, it's a small hearing room. So there's two different two different sets of 5 rows of wooden seats that look like oversized church pews, very uncomfortable. And then on the other side of the bar is 3 sets of tables. So one for Sam's lawyer, one for everybody else, opposing attorneys, lawyers, and then the DEA lawyers, and then you have the bench with the judge and where the witnesses sit. But of those 5 rows, one row was reserved for like the DEA bench, and then the back row was reserved for media. And like there were at most like 2 reporters at any given time. I think a total of maybe 6 reporters the entire time we were there. So like you'd see someone it was, you know, I'm not going to bash anybody, but like you'd see people on YouTube or on podcasts or whatever from the media talking about what's going on. And like them and no one from the organization was in this room. It was basically, I think that New York Times was, I might be missing like one person, but New York Times was really the only like general interest media that I saw or interacted with. Everybody else was kind of marijuana focused, but there were some people who you would think would be in that room who were not. And then the industry really wasn't. There were a couple of attorneys or people who kind of represented law firms from attorneys who were there, but it really wasn't that well attended. And I got there at 5 a.m. on the first Monday that it started. And I did that because I kind of flew up because I was interested. My clients are interested, but I wasn't there for a particular reason. And I thought it was going to be, you know, line out the door. You weren't getting into this small room, and then you can't watch it. And so my boss basically paid for me to fly to DC for nothing. So I was like, I promise you, boss, like I'm going to wake up at 4:50 in the morning, get dressed in my suit, get a Starbucks, and then just stand outside for 4 hours. And there were a couple people who actually beat me there because they were like the paid line holder people in DC that like people who go pay to stand in line for them. But then as the days went on, you still needed to get there early because if you got there later than like 8:50, they wouldn't let you in the building. And then there was always a small chance that you would get knocked out. But that was the first thing. So small room, it wasn't televised, not a whole lot of people there. And I think part of that reason is because I think a lot of people, even in the industry, did not understand this hearing dealt with rescheduling all of marijuana. And that's something I've tried to really beat the drum on. This is something that's being considered. Like we should all be paying attention to this. The other thing, so I'll talk a little bit of meta about kind of the vibe. Mentioned it's weird DEA is taking this position. DEA, I would say, if I had to describe DEA's case, it was basically brute force. So it was like they have their theory of the case. It's very minimalist. It's very specific. And if the opposition made arguments outside of that case, like a 3-pronged case, basically, they pretty much never objected. So in Florida, like if I'm in an administrative case on even like a basic rule challenge, basically whenever you're making traction, it's almost like calling timeout in an NBA playoff game. You disrupt the other side. You try to keep the record from being pristine for them. They did not. Really, the only objections they consistently made were like relevance objections, and it was very rare. And so you had this thing where DEA was basically letting these guys tee off on them. And they're like, we just don't care. That was very striking. That particular strategy.
Were there any compelling arguments against? Like, I think we could all sit here and rally each other and talk about how awesome cannabis is and why it should be Schedule 3 at a minimum and probably logically be descheduled. I think we know those arguments well, and I think most of our audience sitting here is not just financially campaigning for Schedule 3, but I don't know anyone really involved with the cannabis industry. I don't know anyone honestly that uses cannabis that would argue Schedule 1 or 2 makes sense. It seems like people that are pretty out of touch with the plant. But I want to be objective and say, like, is there something on the other side of this? Like, I've got this woman Bertha yelling at me on X right now. I don't even know who this person is, but someone named Bertha is
yelling at you on Twitter.
Yeah, she's yelling me on X that cannabis has no medical use. And I'm, honestly, I don't like to swear on the podcast, but fuck off is my attitude to that, because my dad, who unfortunately passed away a couple of days ago, not looking for sympathy, but I just want to frame the conversation. He, had chronic regional pain syndrome his whole life. By the time he was my age, he was, retired and disabled from car crashes that he got into. So he's taking 1,000 milligrams of OxyContin a day, an insane dose. OxyContin usually comes in 30 milligram pills. That's 33 of those a day that he was taking. And not for fun. It's because he's in so much pain from this chronic regional pain syndrome. He got involved in cannabis 2015 and completely changed his life, and eventually completely got off opiates by using cannabis as his primary pain management tool. Everything about his life got better. Pain got better. Personality got better. All the horrible side effects from opiates went away. And then this woman online is yelling at me, telling me that cannabis has no medical use. And it's like, fuck you. I just watched it in my life. I just watched it with the person closest to me, which is my dad. And I also had a dispensary where it helped thousands of people with real problems. And so, like, I get and very passionate that it's not Schedule 1, it's not even Schedule 3, but if we land on Schedule 3 for now, fine. But my question with this dramatic framing is, what's the compelling argument against it? Because it is not what Berth is framing to me here.
So I guess there's two categories of arguments. There's a process and procedural argument, and then there's kind of the nitty gritty attacking the three prongs that I mentioned that the DEA is putting forward. So the procedural one is what I think is probably the most compelling. I just for the record, I think that DEA is going to prevail here. I think they're either going to get a favorable recommendation from the judge. The way that this works is that, not to bury the lead, but the judge will make a recommendation to DEA. DEA ultimately is the arbiter. They get to decide whether or not they accept that recommended order, or they put out something totally different. And I think DEA is either going to get a favorable ruling, just accept it, or they're going to get a negative ruling and they're going to be like, pound sand, we're going to do it. We're going to go to appeal no matter what. So let's just see in circuit court. But rewinding, the procedural argument, I think, is probably going to be more fleshed out and even more compelling at the circuit level than it was an administrative level. But it's still worth mentioning, which is the process by which HHS ultimately determined that they should recommend to DEA that this should be rescheduled. So this is a little wonky, but I'm going to keep it kind of high level, and we can drill down if you guys want to on any particular thing. But typically when FDA considers a drug for rescheduling, they use what's called a 5-factor test, because the easiest way to get scheduled is something gets FDA approved, and then they figure out what schedule that drug is going to be, because you've gone through the FDA process. When you don't have an FDA approval, but you want to reschedule a drug, they use what's called a 5-factor test. And they've used this for every drug before marijuana and since for rescheduling. And that basically mimics the ultimate conclusions of FDA without kind of that precise double-blind certainty that you kind of get from vetted FDA trials. Marijuana did not use that, and it's because there are elements of marijuana that really, it's very difficult for it to conceivably make it through the 5-factor test. So one of the requirements of 5-factor test is that it be standardized, that the drug itself that's being rescheduled have reproducibility. So it's you can do the same thing over and over and over and get the same result. That you have these kind of very precise causal demonstrated scientific studies. And that's tough for marijuana. And so they created this 2-part test. And so it basically, for that process, you have to prove widespread medical use, and you have to prove credible support for use from studies, basically. And so the point that they got the opposition cross-examined a doctor from the FDA that was part of this rescheduling analysis, and they got him to concede that marijuana would not pass the 5-factor test, and then stated that he worked on this for 8 or 9 months, this ultimate decision, and they made the decision to move to a 2-factor test with 2 months left, and that decision was basically handed down to him by his bosses, whose bosses told him to do that by fiat. So what the opposition is basically kind of trying to create the impression that this was a political process, that this was arbitrary, that this was capricious, and that this is not backed by science. This is they basically had a result they wanted to get to, and they engineered a bureaucratic way to get there. I think DEA obviously had answers to that, but that is an issue you are going to see Sam and the opposed states focus on at the circuit level. There were some compelling witnesses, I think, on the other things. I think testifying about, but they're things that you would concede, that you would understand. But then DEA's argument is what anyone in the industry argues, which is things like diversion. Yes, we understand there are problems with diversion, but there are problems with diversion with fentanyl. But that does not mean, by definition, fentanyl is a Schedule I drug, because it's not. That there are problems with intoxicated driving. Well, if you get hopped up on opioids and you drive a car, you too will cause an accident. And nobody's really arguing that people should get high, pop a 300 milligram edible and then drive a car. So
how about if I take a descheduled drug like alcohol and drive? How does that work?
That's right. That's right. And so that's why I said DEA was very brute force, which was, they said, okay, we have only three things that we're pushing. First of all, marijuana should not be a Schedule I drug because it has medical use. That's all we have to do. We have to show one medical use. And they focused, I think very intelligently, they were very conservative with their approach. They said, we are not trying to prove, there's a couple hundred conditions that marijuana is recommended for if you combine all the state programs. We are focusing on pain, specifically neuropathic pain, on anorexia related to other medical conditions like AIDS, and nausea related to like other conditions or treatments for those conditions like chemotherapy. So like probably the lowest hanging fruit. And I would say from an evidentiary perspective and from a scientific perspective, it's also smart because those are some of the hardest conditions to disprove that you like don't feel better. So if you have pain, like it's very hard for opposition to prove that the people who feel like they're benefiting aren't actually benefiting, because who else? It's very difficult to objectively judge pain, which is also, it cuts both ways. It's opposition tried to say like that basically invalidates the study, that all of this stuff is relative and impossible to prove. But when the federal government puts its stamp of approval on something and says, we believe this, people forget how freaking powerful and resourceful and it's very difficult to knock the federal government off of a position once it takes it.
Mm-hmm.
We've been dealing with that up until this point to get to this point.
Right. And that was really something
right.
It was so interesting to watch the federal government do this too, because it was like, it's a case study in what happens when the federal government wants to admit it's wrong. Like, how does the federal government admit it's wrong and change its opinion in real time when it's they refused to reschedule in the 2010s. And there's record of that. Like, that was cited by the opposition. Like, how do you reconcile changing your mind over the course of a decade? And they did their best to try to justify that.
Yeah, I don't want to turn this into something emotional for me, but yeah, my dad went through chemotherapy, and one of the last meaningful moments that we had was he felt like complete shit from this whole experience. And we have a CPG brand at Leaf called Himalaya, and my dad hadn't smoked weed in 2 months because he was so fucked up from this experience. He was like in the hospital for 36 days, and I won't go to the whole thing, but about as bad as you could get. And he was home for a while, and he looked at me and he said, "Jesse, do you have any weed?" I'm like, "Yeah, of course I have weed. As long as you've known me, I've had some weed. Just tell me which form factor you like." And so it seemed like easiest for him to hit a vape cart. And so I went and gave him a vape cart, and he took 2 hits off of it. He hadn't smoked in, like I said, in 2 months because of his condition. And it was the thing that just made him feel the best. And he looked at me and he said, "Jesse," he's like, "this is magical." He's like, "I can't believe how much better I feel." And so he got really inspired for a while after being so crushed from all the things that were going on. And one of the last things that meaningful conversations he had is he's like, "Where can't you get this stuff?" I said, "Well, if you're in Nebraska, I don't know all the states, South Carolina, what are your prohibition states?" And he gave me this impassioned speech about what to do with my life to try to change that. And so I think that when you look at this, it's, I don't know, man, partially we're talking about procedural thing, but we're also talking about a people thing. When you talk about chemotherapy and the benefit to those people, it's it's an inhumane thing to continue to do what we're doing. It's an inhumane thing to have something so helpful to people. And if you're in fucking Nebraska and you have chemotherapy and you're dying, we're going to prevent you from having access to this. And I understand that it's state level issues here and it's more complex, but man, when you get into, if you're deep into this stuff, all of us are, you're deep into the personal part of it. Some of this stuff is just so offensive to think that Morgan's been through this stuff personally as well, that people trying to prevent people that need access to these things, whether you're medical or adult use. I think that the whole foundation here is just cruel and unusual in some ways, and it's a bit of a diversion from the conversation, but I think it's important because this is about money and all this sort of stuff, and it's about relieving 280E, and I work for a big cannabis company. Yeah, I get it all, but at the end of the day, it's how can we improve people's lives? That's why I think you should be in this industry. I think that's the North Star for all of this, and to hear these conversations. Yeah, you're talking about things with chemotherapy and chronic pain, and to watch somebody in my own life, go through this stuff and have the conversations about, whether we should give people access to this. It's just like, it's just the whole thing just strikes me as a bit insane when you take some steps back to it. Like, it's cool we're going through this nitty gritty process, but for like people that have, lived through some of the stuff and people that have like dedicated their lives to it, when you just take a step back, it's like, yeah, cool story we're getting here, but we're still like, some of this stuff just sounds like insane conversations to me about like whether this, has this kind of value.
Yeah.
Morgan, why don't you take us to the next section here about reading the tea leaves? Let's talk a little bit about where we go from here.
Yeah. So, I definitely heard a bunch about the, hanging on this procedural thing, and not to kind of go back a little bit, but it was my understanding that the two-part test was not new. Like, I mean, it's relatively new in history, but wasn't this like a couple of years ago that they introduced this understanding that it is not a pharmaceutical drug, it is not processed down to the compound, it is an organic plant, so that it's apples and oranges. And so, like, I'm trying to remember when, because I thought we wrote about this to our investors, and I thought it was like 2 years ago, like 2 falls ago.
Yeah,
and saying this is an important thing.
So what we're talking about is actually a very important. And I see a comment coming in. It's an important like legal point that you're making. So, legally speaking, DEA is bound by HHS. When HHS says we picked a test and we use this test is valid, DEA is bound to accept it. DEA doesn't have the legal authority to test the test, basically. So FDA, HHS, HHS's recommendation to them based on the FDA analysis is gospel, scientifically. DEA is like kind of an arbiter of, okay, we understand what you're saying, but they still kind of they have some wiggle room to decide what they're going to do with that information. So that test is legally binding, right? The test is legally binding. Yeah. But just because the test is legally binding is not going to keep the opposition from challenging that, like, that the test fundamentally in and of itself is illegal or is arbitrary and capricious, because you're now taking up to the circuit court. You're now in the appellate process. So in the appellate process, you can attack not only, I mean, the facts are kind of decided. You can attack process, and you can attack, okay, we understand what the law is, but like, or what this judge said, but that was fundamentally wrong. That's in bounds for a circuit court appeal. The second thing is that, like, even if you use that two-part test, that the conclusions that you drew from it still don't support your argument, which is what they're also trying to argue. So your point is well taken. It's there will not be an outcome in this administrative hearing where the two-part test is, I think, invalidated, which is why I was like, I think this is probably more interesting for the circuit court than for the administrative hearing. For the record, I think DEA is going to win this.
Yeah. So this is. I'm going there because I, maybe off script a little bit, but is that where this is potentially going next? Is like, instead of having a hearing, having they say like this should be rescheduled, and then is this where Sam is going to come out next? Is they're going to push this into the appellate court system? Like, I mean, you know what I mean? Like, is that?
Well, they're already there. They're already in circuit court on. There's already an ongoing circuit court case over the rescheduling of medical marijuana. And like, yes. So right. To answer your question, this is unquestionably going to be going to circuit court. I mean, I guess anything is possible, but like, this is going to go there. They're going to make these arguments. How this process moves from here is, so they already did the notice of proposed rule. So now the ALJ has, it's typically like on an administrative case, 30 to 90 days, although this is kind of fairly complicated, high profile. I wouldn't be surprised if it took a little bit longer than that. ALJ is going to make a recommended order. Once you put that recommended order out, every party to the case gets 30 days to file what are called exceptions, which is like, okay, judge, we read what you said. We think that this recommendation is wrong in these ways. Then DEA reads the record, they read this recommended order, they read the exceptions, and then they make a final determination, and they make their final agency action. The final agency action is the end all be all, and that is what would be ultimately challenged in circuit court.
Okay. And I'm just trying to think, because like from our industry's perspective, now people are starting to project like by September this is going to be this, and by October this is going to be all done and everything. And but if I hear, you know, circuit courts and I hear like they don't move that fast. Like I mean, like, and I guess, you know, just putting that aside for a second, is like, were these hearings beneficial in moving things forward, or was this actually helpful for the opponents to get more ammo to try to go into the courts? Like, I'm just trying to understand, like, I mean, it seems like, to your point, the DEA's got its mind made up, but, you know, also, as you were saying a bit earlier, to some degree, the DEA is basically the cops. They don't write the rules. They're just enforcing the rules for the most part. And now, you know, so like, I'm just trying to understand, like, what was learned, like, is this making the DEA's position stronger? How does this set them up to then have to deal with Sam in the courts?
Well, okay. High level, because there's a lot to unpack there. High level, I would say that if you talk to any administrative lawyer that has done, like, has practiced administrative law for any period of time, like, they will tell you that those are uncomfortable conversations that we have, because this isn't civil or criminal law. Like, you don't get the certainty of a judge making a decision, pounding a gavel, and like that's it. Like, the administrative process is porous to challenges for a reason. It's like the whole decision, the whole way through, this decision faces the gauntlet of administrative challenges. It's procedural. Now, like, this is why Congress acting would be a way more efficient process than what's currently happening, but that's not the world in which we live. So it's hard to predict, because like even in the medical marijuana circuit case, right? There was discussions about, because the opposing parties in that case, or the petitioners, are seeking a stay. They're basically seeking the judge to say, stop what you're doing, like, stop registering these businesses with DEA, stop these DEA inspections. Like, we need to keep the Schedule 1. And like, there was speculation that stay would be ruled on prior to this hearing, and it wasn't. So even there, like, that's confusion. And I think what ultimately, like, I think cannabis companies, cannabis investors, their, like, capital is probably the thing that keeps them up the most late at night. But like, in my opinion, the capital concerns, all concerns in marijuana right now, basically boil down to confusion about, like, regulatory certainty. And like, people really don't know the rules of the game in advance, and the rules are being written as we proceed. That's what's happening here. So like, I will tell you, illustrative of this point is, I have spoken to DEA agents on the phone through a registration process. I spoke to people who work for the DEA while I was in the DEA building at this hearing. And then you listen to the lawyers, and like, they're saying different things. So like, there are parts of the DEA that are not thrilled about this. There are parts of the DEA that it's their job to defend this. And then there are people who are happy that this is happening. So I think, first of all, I would tell the industry is like, you should be cautious about how, like, open the DEA and optimistic you are as to what the federal government's actual position is on this, because there's a difference from arguing something legally in court and then like actually making it work in real life when you're dealing with the DEA moving forward. And it's possible that they're doing this now, but like, functionally working with them might be quite difficult. It might not, but it might be. It's also like, we don't really know how some of these circuit court we don't know how the administrative case, we don't know how these circuit cases are going to go. We don't know if stays are going to be granted. We don't know if ultimately opposition could prevail and we have to go even higher up the chain. So I think I would love to talk to anyone who is like 100% convinced that they know what is about to happen, or can like predict even the next 6 months of the future, because I think that person could make a lot of money if they're 100% certain on what's going to happen next.
Kalshi.
I don't know if you followed this, but there was actually a funny Kalshi story on the rescheduling. So I have a buddy who bet a lot of money on rescheduling not happening over the summer. And I texted him. He woke up in a very cold sweat that final order came out because it was, it rescheduled medical marijuana. Okay, but Kalshi determined that because it was a partial rescheduling, it didn't count as full rescheduling. So we got to hold on to his money.
That's funny.
Yeah, but let me say one more thing though on that is ultimately this is incredibly good for the industry, because if you kind of step back from the riptide of what's happening right now, the day-to-day drama, or even the week-to-week drama, the federal government is putting it on the record that this is a beneficial thing, this is a good thing, and this is the direction we can go. Which means if the federal government changes its mind at some point in the future, they're hosed in the same way that they're kind of hosed now by their previous position. Like anytime the federal government goes on the record and says, we are proponents of marijuana, we are proponents of taking favorable action to marijuana, that is, any lawyer in the country now can use that in federal court or in state court as to justify the positions that they're taking. And I think once you get medical marijuana anchored, you're going to have some arbitrary and capricious and some equal protection arguments for people who are trying to get recreational done through the courts rather than through the executive branch of the government. It'd be very, I do not understand if you can get through this medical marijuana stuff and just medical marijuana anchored. This is legal. This is federally acceptable. I don't know how the federal government withstands an arbitrary and capricious argument when they try to enforce a Schedule I determination, or they try to make some adverse executive action against an adult use user or an adult use grower or an adult use distributor, when you walk into a dispensary and like these are the exact same products, and the federal government is asserting there's no difference between these products. It's going to be like they have cemented their position, which is excellent for the industry moving forward.
And if you let's say you ran Kalshi, Christian, what would you put the probabilities of adult use being rescheduled in 2026?
Administratively, I think DEA coming out and doing a final order, I would put probably 80 or 90%. Like I feel pretty confident in my prediction that one way or another DEA is going to move forward with this. In circuit court, I don't really know, but like the thing that's important for people to consider on this is that once you get into circuit court appeals, you're talking like years. You're talking a lengthy process. And we don't know when the final order is going to be issued. There's not really a drop dead date for this ALJ. And then once DEA gets all of the paperwork, there's not really a drop dead deadline for them. So we're definitely going through midterms, I would imagine, on the ultimate DEA recommendation. And then you're talking about having circuit court cases going into the next presidency. We'll have at least two sweeps at Congress. So it's like at some point when you have these American MSOs entering exchanges, when you've accepted the 280E improvements, when we've these DEA inspections have been carried out and all these businesses are registered and interfacing with the federal government. It's like at some point all of these things become entrenched and become almost impossible to claw back. So it's winning by inches, but each inch that we gain is like intractable. It's very difficult to claw that back once we've made progress.
So what are the practically speaking, and I apologize for being naive on these topics, but a lot of these legal things I don't get into, but if administratively we get the final rule on adult use being moved to Schedule III, what's the implications of these circuit court cases? Like, does that, for operators, does that change? Do operators finish 20? If you're correct, and this moves how you expect it, but we have these objections, appeals, whatever the right term is in the circuit courts, what's the impact to to a Cure Leaf or a Verano or even my company, Leaf Brands, in terms of 280E and other things related to that classification?
Yeah, the taxes get better. 280E, because 280E is a prohibition against expensing basically any of your expenses as a business if you're dealing with a Schedule I drug or a Schedule II drug where it's not legal in the jurisdiction in which you're like a state that's not legal. So what 280E is going to be an improvement. I think as far as certainty for like banks, insurance, like I think probably DEA registration is going to be something that they ask you for. So there's going to be kind of reciprocal certainty on some of these processes. On the product side, I don't think it materially improves as far as like legal certainty, because, and this is a little wonky, but when you're a Schedule 3 drug, think about it as like, okay, now we're a Schedule 3 drug. It's this is ketamine. This is like prescribed testosterone. This is anabolic steroids. So these are products that each go through their own approval and are deemed safe and effective. So when you move the entire category of marijuana to Schedule 3, okay, that's fine. But like, the marijuana industry is composed of a constellation of products, and none of those products will be approved by the FDA as safe and effective. So the category itself moving into Schedule 3 is good in that you don't have a Schedule 1 prohibition, which means by definition you are a drug smuggler and a money launderer. You're out of that, but your drugs are now a medical product without medical approval. So I think the recreational marijuana and adult use programs will continue. I don't think they'll be materially changed, but that problem doesn't get unstuck because of rescheduling of marijuana to Schedule 3.
And I hear that objection sometimes. I actually I think I heard it yesterday about somebody saying, well, what are you going to do? Because none of your products are FDA approved. Like, how do you think about that, Christian? Like, there used to be products out there, Morgan, you remember Dosist, right?
Of course.
Yeah. So you see products out.
Let me see the question. I mean, not to be like cynical, but like anybody who's been in this industry has been selling a Schedule 1 drug for, going on 2 decades now. So it's like it's a distinction without a difference. Like, it's better to be Schedule 3 and to be operating in a legal gray area than to be Schedule 1 and operating in a legal gray area. But so in order to like, one of the situations DEA is going to run into, and the registration process is a perfect example, right? So medical marijuana company, and I'm not talking about adult use, just medical, right? These medical marijuana companies now are registering their businesses, but the DEA didn't build a portal and a system or promulgate a rule and a form for marijuana dispensaries. And so what they are filling out are basically like slightly modified Form 224 and Form 225 for dispensaries and manufacturing facilities. Those are pharmacy and drug manufacturing forms. There is not like an independent rule about how DEA specifically deals with these companies that have now been deemed Schedule 3 providers because they're compliant with the state program. And in order to do like meaningful enforcement actions, like you need rules, you need standards, you need like things that actually have to be promulgated. So I think that I am one of the people that I do not expect crystal clear certainty from the federal government in the next couple of years. What I am very happy about is that my clients are likely no longer going to be operating in like an absolute legal dead zone of being Schedule 1.
Let's say you're sorry, just one quick one. So your Leaf brands were one of, if not the biggest producer of concentrates in California. Well, of 75, typically up to 100, what we call fractions, which would be like, you and I were talking backstage, like Gorilla Glue shatter would be a fraction for us. And over here, I've got some garlic juice rosin, and then we sell a whole bunch of distillates. We've got all these different things. And so how do you think about those specific products, like in that FDA context? Is there any world you see where each SKU that somebody has to be somehow, federally approved? I understand that seems insane going, we were Schedule 1, now we're Schedule 3, but there is that concern out there. There is I think, Christian, if we're fair, there's like a bit of a contradiction going on there, right? Like we're a bit of an exception to the rule where we don't have a specific product with this whole category, which is cannabis, starts with our flower back here. But again, look at Leaf. We turn that flower into 75 different kinds of oil. Like how do you think about that context in this FDA frame in an FDA framework, or do you think just we're just a lifetime exception to that?
Yeah, I think that the FDA, the Attorney General's final order kind of, I think, signals how they're going to treat that. which is they've kind of put baby in a corner with the FDA, which is they say that like medical marijuana, like Florida MMTCs under that final order are operating as Schedule 3 producers and Schedule 3 dispensers by virtue of being compliant with the state medical program. So what they've essentially done is incorporated these state programs into by reference. Now, there will be restrictions for like your company. There might be the DEA might be particularly concerned about chain of custody, security, your cameras, record keeping, background screening for your employees. Like they may be concerned with that. But as to the actual like approval of those drugs, the way that the federal government is handling that is they aren't really requiring FDA approval. They're just saying if you're compliant if your product complies with California state law and you are a licensed in good standing entity in California, right now the federal government has said you are a Schedule 3 manufacturer, or you're a Schedule 3 distributor, or you're a Schedule 3 dispensing, as long as you register with them.
It is interesting.
Check with your California lawyer.
Yeah. Well, I mean, I think what's important with all of this is, like Jesse and I, we talk about this a lot, is trying to think about not what's just happening, but and then what, right? And like this is just uncovering like just because we get to Schedule 3, obviously massively historically important to be progressing in that way, but it introduces a lot of other elements that are still murky and still living in with some uncertainty. I understand like FDA is still, or keeping the baby in the corner kind of thing, and maybe that's why we saw descheduling law proposed today is like, this is a wake-up call to Congress to get your shit together and finally do something. And because the cleanest thing for this industry to thrive is got to be descheduling. Because I just hear this rescheduling, I'm just like, for capital to move, for people to start wanting to be back in this industry, obviously they want tax clarity, they want regulatory clarity. And I feel like, if we get final rule and 280E stops for all of the industry, not just for medical, but we still have this overhang of these challenges in the courts, and what if they prevail? And then what does that mean? Does that then go retroactive back? And like, what I mean? I'm just trying to put my hat on as if I'm an external capital group looking at cannabis and I'm seeing this landscape. Does final rule actually give me certainty that there is permanence here, or is there still some risk here that is, this kind of court overhang versus, like you said, if Congress would just do what the American people have wanted now for quite a long time and just deschedule it, we would be free of all of these issues. Is that fair?
Yeah. Or if you get FDA and DEA to agree with you and just deschedule, like they could do it. They could deschedule if they wanted to. They haven't.
Right. But it seems like that's a huge step from going from Schedule 1 to just go right to deschedule. Though I do think, I understand. I'm just, politics are.
No, I'm shaking my head the wrong way, Morgan. I'm agreeing with you. I think that's what we should do, but I think that jump is unrealistic. Yeah,
exactly. Yeah. And I did even hear right in the rulings or in the hearings, wasn't there a physician or someone that did acknowledge that cannabis or marijuana has less harms than alcohol, less addictive. And obviously we know these things, but the fact that it was in the hearing and I think Sam was the one that was pushing back against this, of like, they had a descheduled substance being in the hearings. It was like conflicting. And it's like, I actually thought that was a very powerful thing, because to admit something like that in court, I thought, well, does that open that door? Or to your point, Christian, are they so anchored on our position as rescheduling, and that's where we're holding?
I'm trying to find the political way to say this, the politically correct way to say this. I would not attribute.
I told someone to fuck off earlier. We're not doing political stuff.
I don't know.
Let's get the straight answer here.
I don't know if they. I don't know. I honestly, I don't know if all of these permutations have really been thought out by the administration. Like I'm not sure that they're like when you're talking about this, I'm not sure anyone has actually gone through these and like actually like this is organized, cogent, like political action. I think part of this is red meat because we're going into midterms. Part of this is something where it's like we have to have some type of press release because the law has become so like utterly ridiculous in how it's being handled nationally. And part of this is like, Trump taking a win, like Trump being like, okay, we're going to do this. I'm going to actually make this happen. And he does have a tendency to sometimes, shoot and then aim on some of this stuff. I don't want to say like DEA and none of these people, like obviously a lot of thought went into this. Like this is but like what you're talking about are like so many permutations. It's such a complicated situation. And there might be, think tanks or particular people in some of these agencies that have thought about pieces of this, but how the whole thing fits together, I really don't know. I don't think that there's like this grand plan about how all of this fits. And even if there is, we have elections every 2 years and it's going to take more than 2 years. Like any of those things can be accelerated or disrupted.
And I mean, I think one thing that's a minor thing but I'm keeping on my radar is if they don't get this final rule done and Massachusetts voters actually vote to repeal their adult use market, what's that going to weigh on the calculus of the DEA's position? You know what I mean? So like, there's like a window where I think, get it done, but does that give more ammo to Sam in the courts? Like
maybe, I mean, but like it's possible, but so this is actually kind of interesting. We talk about something that specifically happened in the court that like, I mentioned the brute force thing, but I didn't really really give any kind of flesh that out. But DEA treats those types of things as irrelevant to what they are. And they're arguing in front of the judge that what you just described is irrelevant. So specifically, they treat like how state governments, specifically adult use state programs, have comported themselves. They think that's totally irrelevant because the case is about whether or not there is an accepted medical use for marijuana. So, you compare, you could have a state that's, and there were examples of kind of, some not awesome things happening, as far as certain states that are kind of lax on certain safety requirements or diversion prevention. And it is what it is. DEA's position is we don't care. That's diversion. Like there's diversion of fentanyl. That doesn't mean fentanyl doesn't have an approved medical use. Marijuana has a medical use. So same thing with, diversion in particular. FDA, I would say one of the weakest parts of their analysis probably is diversion. Just saying that, like as someone who watched them, like their explanation for diversion was basically looking at kind of like federally involved, like NIDA facilities and how much diversion there is, and there was no analysis as to like, or very very little analysis of like real diversion in like these state medical programs. But DEA's position is that doesn't matter. There's diversion for every drug. That doesn't affect medical use. So back to like one of your first questions, that's why DEA keeps bringing back the medical, because it helps them push away things like diversion or well-run state programs, because they're like, yeah, that's all true. It's debatable, but it's true. Whatever. That doesn't, even if you accept everything you say, which we don't concede, it doesn't matter. That's their position.
No, that's a great point. And you did mention that earlier. It's good to bring it up again because it's easy to get like too far down and get lost in it, and that brings it back. Because, I mean, at the end of the day, the states just created these programs because the federal government was not willing to move at that time. And so they wanted to have these things. And then we created this funky thing where we had medical, and then we created adult use. Like those were all created because the federal government was not formally, or was, historically had not been in favor of doing this. So, which created all this, nuance and, and point about, diversion. Yeah, that's a regulatory and enforcement question. That's not around a medical value perspective.
Yeah, I mean, the opposition were basically trying to make the argument that like it's so pervasive that it becomes a public health issue rather than kind of like a criminal or like administrative issue. And like I said, the DEA's position is what the DEA's position is. And some of that, they provided expert testimony on that. They provided a lot of information, but they had the sheriff from Humboldt County came out and gave very compelling testimony about organized crime in California and how the county, there's certain parts of their county are a mess trying to deal with this stuff. And then it's very arduous and the system needs to change. But DEA is we get it. That doesn't impact our analysis though. So.
Yeah. Interesting hearing the Humboldt County Sheriff talk about organized crime, but that's a much longer conversation.
The phrase "murder mountain" was said probably 10 times during his testimony.
Yeah. So Christian, just to kind of wrap things up, we covered a lot of great ground today. It's been a really helpful show. When you kind of reflect on the time that you spent at the hearings, and what's your single biggest takeaway you would leave listeners with?
I think that having DEA witnesses talk about the entourage effect, and DEA witnesses talking about medical use, and DEA calling witnesses who are testifying about how patients can affirmatively be helped off of opioids with marijuana, getting this stuff on the record, the federal government taking these positions is extreme. It is the most valuable thing from all of these. It is more valuable than the outcome. The federal government building a record for why it believes is something that they can't ever take back. They're locked into this now. So it was the last 2.5 weeks are probably definitely since the Cole Memorandum, the most important, federal policy shift that we've had, because once you put this out there, you cannot take it back. So the opposition is going to do what the opposition does. I will say that opposition lawyers, some of them were terrible, but some of them were incredible. One of Sam's lawyer, I give credit where it's due. He's the best litigator I've ever seen in person. He had this, when I mentioned that he got the DA witness to concede on the record that marijuana would not pass the 5-factor test. To do that, he got through about 30 minutes of concentrated. It was the one time DEA actually fought. They fought this guy for 30 minutes. I've never seen someone break through objections and be able to get a Matlock moment like that. It's very impressive. So their lawyers are excellent, but some of their lawyers are excellent. But the fact is the most powerful ally that you could ever hope to have is the federal government.
Yes.
U.S. federal government is now the ally that we have mutual interest in this particular area. And it's incredible to see them take the positions that they've taken.
Yeah, what a massive shift. There's a great book called Smoke Signals, which Micah, our CEO, have you read that?
Yeah. I read that. Yeah, I read that back in the day.
It's a bit dated now. I don't remember when it came out. I think it was before California even adult use came out that the book was written. But I bring it up. Yeah, it's called Smoke Signals. Hirsch, one of our favorite guests, Hirsch Jane, has read it too and liked it a lot. And yeah, I bring it up because great book. Everyone should read it if you're into cannabis stuff and you're a nerd in that regard. The history of it is just amazing. But the biggest thing I took for the book was for thousands of years, people have wanted cannabis, and the government has tried to suppress it or oppress it. And it goes back to not even just the United States. It goes back so much further than this. There's this great plant that people continually want access to. And for hundreds of years, maybe thousands of years, we're trying to, stamp it out, stomp it out, get rid of it. Take this, don't take that. Take this, don't take that. But people keep saying, I want this, I want this. It even goes back to, you probably remember, Christian, the jazz musicians and all that sort of stuff, then into the beatniks, then into the AIDS movement in San Francisco. And over again, people want access to the plant, period. Some for really serious medical conditions like my dad that helped change his life. Some just for people like me, who I'd rather smoke a bit of weed at night than drink or take any pills or do things like that. And to each their own. But for so long, we've taken that choice away from people. And that's I think it's fundamentally an inhumane thing to do. And I think it's one of the biggest things society has gotten wrong is by not giving us that choice to do something different. Hey, man, may not be for you, Mr. Politician. Mitch McConnell, don't want to get stoned? Awesome. Don't do it. Usually I don't want to drink. Awesome. I don't do it, but I'm not out there with signs and trying to take that away from me, even though alcohol is a million times worse for you. I would tell people not to drink, but hey, if they want to do it, kill themselves, feel bad, all that sort of stuff, that's a trade-off. That is 100% their choice. And it is so important to point out that there's that shift going on. And the shift is just acknowledging a slight portion of reality. I don't even think that's acknowledging the full reality of the situation, because I think we need much more medical information, not just on THC, but what about, CBN? What about THCV? What about CBG? This great guy in Humboldt who helped me out put together a custom tincture for my dad of like THCA, CBGA, and maybe CBCA. I hardly know what those things are. I've been in the cannabis industry passionately for 10 years, and I'm just learning about these acidic forms of cannabinoids that may help people. So there's so much out there, from the basic guy who just wants to smoke a joint at night to relax to really complex situations like, chemotherapy and somebody, in cancer, where guys would work for my dad just in case this is sadly, he never got to take it, but what was given to my dad and formulated for my dad was a couple of tinctures. One was 50% CBD, 50% leaf GMO rosin for that, balanced THC, CBD, bunch of great cannabinoids and terpenes and different things in the GMO portion that are helpful. Then on top of that, a separate tincture with these acidic forms, and all of that works together to accomplish something. Do you guys know how hard that was for me to find out? Do you know how many conversations I had? Do you know what I went through to put that together? Thank God I worked for Leaf and could get the rosin. Then I sent it to somebody else who did the formulation. Then it was sent over here and eventually made it back to me. And that's just one example of the way that we can help people that's super complex. Then there's the simple things, guys, just like me and Morgan, who like to smoke a little bit of weed at night. And for so long, we wanted to do that. And for so long, someone else is out there, not just saying, I don't think you should do that. If you have an opinion, you say, I don't think you should do that, but they're making it fucking illegal to do that. And yeah, I think your point is so important to wrap on here, Christian, because finally, someone is acknowledging some of these basic facts. And again, I don't think they're even acknowledging the full truth. It's moving way too slowly. We want to get the descheduling. But I guess, Christian, when I look at the end, we'll see what happens. But it feels like, in some ways, like you're saying, there's maybe a huge win embedded here. And hopefully we get the financial part where 280E goes away. Hopefully that goes back a few years retroactive on the Treasury stuff. But I think your point there, Christian, is fantastic about the government finally realizing some of these things that all of us know.
Yeah, absolutely.
Freedom 250. It's
yeah.
time.
So let's wrap things up, boys. Thank you to Flowhub for making today's show possible. With cannabis rescheduling moving towards the goal line, the industry is continuing to evolving super quickly. And you operators out there, you have to be ready for that change. Man, at Leaf, we have never been busier adapting to these changes, whether it's on the retail front, the wholesale front. We didn't even get into the DEA stuff, but all of that is super fascinating too. But guys, if you've got a dispensary, Morgan talked about these AI hooks. If you got, one store, you got 10 stores, you got 50 stores, it's really just a fantastic time to be looking across your tech stack and figure out what you could be doing differently. So just take a few minutes, guys. Jump over to flowhub.com and schedule that demo today. So thank you to Flowhub for continuing to support the show. We really appreciate it. Morgan Paxia, always a pleasure. Christian, thanks for joining the show today. Really great to meet you. Hope we stay in touch.
Thank you, guys.
And we'll see you guys again in 2 weeks. We're working on a show with a big operator, so we'll see if that works out. But rain or shine, we'll see you guys back here in 2 weeks. I always appreciate you joining us. If you're on YouTube, that channel continues to grow. I think we're pushing 360 subscribers over there. It is the biggest growth engine for us. So go check out YouTube. If you're on YouTube, do me a favor, like, subscribe, and if you're really a fan, hit that bell for the notifications so you know when new shows come out. That's it, guys. We're out of here. The views expressed in this podcast are provided for informational purposes only. Nothing I said, Morgan said, or Christian said should be considered research or a recommendation. All investing involves risk. You're a cannabis investor. You know that, including the loss of principal.